if you didn't get caught, you would say nothing, either to your treatment, certainly not to the court, it seems.
Mr. Williams, please state your name for the record.
Jason Williams.
Your Honor, we're here for a pre-trial. There's also a pending bond violation.
There is.
I have spoken about the violation with my client. I believe today he's going to admit to the violation, and he would like to make a statement on his own behalf.
Yeah, so that being said is I admit to the violation, and I know I wasn't supposed to have alcohol in my system. No excuse, but the last few weeks, sir, I had so much going on in my life, money issues, the car issues, whatnot, family issues, and no, there's no excuse because you said what you said, and I wasn't trying to get in trouble or anything, and I've still been going to my program, and that's still been helping me. So going to my program weekly by weekly and dropping with them and whatnot, and just still trying to grow as an individual and whatnot. So that's all I have to really say right now, sir.
If I may, Your Honor, add to that. So Mr. Williams is attending substance abuse treatment in Detroit. I believe it's called Community Care First.
Yes.
He goes there weekly for group therapy and is also attending AA meetings.
Do I have any documentation regarding any of that?
I believe I have provided to Ms. Londy. I'm happy to give it to the court. He gave me his schedule and
but how do I know that he's actually going to that?
Is that what?
I have his enrollment paperwork. I'm happy to get an updated progress report from that program and get that to the court.
And we sign in every week. So
we
sign in every week. And I think you said that's part also. Talk down.
How long has he been doing that?
I've been doing this going on 3 months. It's January, February, March. Almost going on 3 months.
Nothing, well, I was going to say nothing, but I did want the court to know he is fully employed at U-Haul. He works full-time there. He is hoping to stay out of custody and continue working, continue going to his treatment program, and just, get things back under control.
Yes.
I'm sorry, what is that?
Oh,
Ms. Londy.
In anticipation of the court accepting the admission to the bond violation, people would request enough change in bond conditions. First and foremost, there was a prior bond violation in March that the court accepted the admission to would allow the defendant to continue testing with where he's testing now. Unfortunately, this is an OWI case, and it does have a prior from 2012, and now this is the second time that we've got an alcohol violation. So I am requesting that he be placed on a scram tether. I do believe that community safety and the public safety risk of having this person not be on 24-hour testing supervision is too great to ignore at this time. So I am requesting the court order that and have him placed on the scram tether.
My problem is that and this is why I don't like to do it this way. I gave you a chance, Mr. Allen. I gave you a chance with the last violation. What?
Sorry, just for me to speak, I wasn't informed that about so I didn't know anything about the last violation. Like this would have all been like this wouldn't happen again. It wouldn't never happen again. Like it wouldn't never happen again. Like I say, I'm still just I'm working on it, sir. I definitely apologize. I'm just hoping like you could please work with me just one more chance, and you won't hear about it.
Here's the thing. I don't mind giving people chances, but I gave you an opportunity to test in Novi with results to community correction. I did that back, I think it looks like on March 5th. And I get these negative tests. Well, first of all, there were like numerous miss samples.
No, oh, sorry.
I'm going by their report.
Okay.
Then I get negative results. Then on March 27th, I get, well, that's when the ETG comes through. I get a positive alcohol result. Here's part of my problem. I don't know how much you're drinking. And so that comes through, you know you've been drinking. And then on the 2nd, we get a negative result from your ETG.
Right.
Then by the 9th, you're drinking again.
And the second. And that's like,
What?
I'm just up here thinking, sir. Like, second, like, knife should have came back negative also.
It came back negative.
Yeah, negative on the second.
On the 2nd, it's negative because
Right,
it's only going to pick it up for whatever period in time. But then by the 9th, you're drinking again. Or sometime shortly before that or before that, you're drinking again. And I don't have any reason to doubt anything, but I don't know what treatment you're in. I don't have that in front of me, first of all, right now. I understand why I may not. But also, I don't even understand or nor can I trust what you're indicating is your participation with it.
So, like at the meetings, sir, there are 2-hour meetings every week. Like they're NAA, talk to a counselor and whatnot. And like once again,
Did you tell the counselor you're drinking?
you said, well, did I tell the counselor I'm drinking? No, I'm not drinking.
Pardon?
I'm not drinking. What? Like, I'm confused right now. You said that.
Pardon?
Did you tell your counselor that you had the positive
Oh,
alcohol test?
no, because
didn't.
I just got informed. I just got informed on Monday. So I was going to tell him this.
Well, hold it. Whether you got informed or not, you knew you were drinking.
No, I just got informed on Monday that I violated. That's what I'm telling you on Monday.
Okay, listen real close to what I'm saying. Whether you were violated or not, right?
Right.
You knew you were drinking. And so my question is, you knowing that, did you tell your counselor you were drinking?
No, I haven't spoke with her yet. I was going to speak with her on Friday about that and tell her, like,
I thought you went every week.
I go every week.
Okay.
Every week.
So today is the 23rd, right?
Right.
No, just listen to me.
Okay.
Today's the 23rd, which means presumably from the time of the results, you had at least 2 of those meetings. And you haven't told your counselor that you were drinking. That's from the last instance.
All right. Last week, sir, we was off due to Easter on Friday. So we
Here's the
didn't.
problem, young man. You're going to have to get your addiction under control. You got an excuse for everything. If you didn't get caught, you would say nothing, either to your treatment, certainly not to the court, it seems to me. And then you would go about continuing to drink. I'll adjourn the matter to May 21st, 2025, 9 a.m. At this point, given his violation, his admission to the violation, defendant's bond is hereby ordered revoked. I will reconsider giving him a bond and maybe releasing him with certain conditions once I see the information or the progress report.
I was going to ask, Your Honor, do you think that we could get him assessed by the jail and see if there's any treatment programs that this county can offer him maybe a higher level of treatment than he's already engaged in.
Well, I don't know what he's engaged in. I mean, I can't, because what he's telling me doesn't make a whole lot of sense.
Well, I'll get that to the court and whatever other information I can obtain.
All right. Thank you.
In the end, this case wasn't just about alcohol. It was about honesty. The court didn't just see a violation, it saw a pattern of excuses and a failure to take real accountability. When someone is given multiple chances and still chooses not to be truthful, the system has to step in to protect public safety. Rehabilitation only works when it's built on honesty, not avoidance. The judge made it clear, trust, once broken repeatedly, becomes nearly impossible to restore. But here's the real question. Should the court have given him one last chance, or was this the only outcome left?